Good day. I am very glad to start our first activity within the agenda of our conference, and because the idea of the conference was to look into the nearest future that awaits for us to understand what will be the situation with prosecution of perpetrators in international crimes that are happening every day now in Ukraine. And if we talk about international criminal crimes, because we should follow the international practice in criminal prosecution of perpetrators. And if we want to understand how international war crimes will be prosecuted in Ukraine, we understand what awaits for us in the field of international criminal law. And Mr. Mykola, I am very grateful that you find time to join our yearly events on the topic of international criminal justice, and I want to congratulate you on ratification of the special tribunal on the crimes of aggression that was established recently, and Ukraine was one of the co-initiators of this tribunal, and I'm very grateful to the colleagues from European Court on Human Rights for the titanic work you've done, and which enabled adoption of decision on the case Ukraine and Netherlands versus Russia. Thank you, Konstantin. You know how to say a lot of good words about me. Yes, yes. For me, it's a great joy to participate in this discussion and within the scope of this week of Ukrainian International Criminal Justice Week. Thanks to the Center of Liberal social liberties, and this is a structure that backs a lot of positive processes in Ukraine, in legal sphere and around Ukraine, and especially they're working actively in the field of international criminal justice, and the fact that they are cooperating with Professor Zadoya faces that they're very serious in their goals and tasks. Yes, and the results are very important. Thanks for this opportunity to have discussion with you. I hope we will not be tiring participants of this panel, audience of this panel, and but yes, we will nevertheless try to look into the future and maybe more talk what is our current situation and how it will influence our immediate future. And I want to start with such thought. That international criminal justice and international criminal law, they immensely interconnected, and they depended from the general condition in which our global world is now, and global community, how they interact. Like whether the war is present or absent, whether basic human rights are respected or not, or disrespected, whether societies and states are ready to make conscious choice in favor of justice, in favor of just future, in favor of happy future of humankind. When we talk about international criminal law, we talk about the future of the humankind, because this is the project that wants to make humankind better. That's I thought I wanted to introduce, and maybe we will continue with the further. But let's start proceed with our Q&A session. But in order for the audience not to get bored too much, I will not be asking questions to Mr. Mykola, but I will be just say my forecast about the future of international criminal law, and Mr. Mykola will comment whether he agrees or not with that. And I hope that maybe some of the forecasts that we will be mentioning will not be happening, but nevertheless, we'll have to discuss this. So, forecast number one, until 2030, Ljubljana-Hague Convention on international cooperation on investigating and prosecuting perpetrators in war and international crimes will be enacted. I think these conventions should be split. The prospects of their enablement are different from the point of view of phenomenology. Ljubljana-Hague Convention, it's oriented on it's more focused on Putin, because the formal requirements for it to be valid as international treaty, they're quite low, and they they will depend on how many countries will join that convention, and so the issue is how many countries will join and will be ready to enact it. And in particular, in criminal cases, on cooperation that is related to fighting international crimes, and it will depend on how wide will be the circle of the participants of the convention.
It will be like a set of bilateral agreements between the states. So it is torn apart into these bilateral relations very easily. It's important to have a lot of these combinations so that as many as possible countries would fall under this convention. It is pretty technical, but it's very important concerning the UN Convention on crimes against humanity and punishment for them. My impression is that the International Law Commission and its course of work and the Commission's further reaching of international agreement, it stipulates slower pace, slower movements. As far as I understand, the convention will not be finalized as a document that is signable not until 28, maybe until later, and if in late 28 and early 29 it will be finalized, it will be opened for the signatories, the signing will take place, then the ratification, and then this convention as the result will probably gather more participatory countries than the Hague Convention. But it's going to be slower, and I must say that convention is pretty interesting because the attempt to use the convention on genocide crime and crimes against humanity, it is obvious, but it's got a lot of nuances. So I think that the Ljubljana-Hague Convention will become effective until 2030 and the other until 2040. Thank you for those projections, and I propose that we talk about international criminal law sources, which is the Rome Statute and the changes to it. That is quite a bit of talk today, and the projection sounds like up until 2030 the ecocide crimes will be within the jurisdiction of the International Criminal Court. It is very, very interesting, yes, indeed, and I need to say that that ecocide crimes, my position about that has changed over the last 15 to 20 years, maybe quite maybe for the opposite, because I was very skeptical. That was what I started with. Ecocide, investigating on ecocide wasn't very much of a serious initiative. There was also the national criminal law that worked according to the UN, and then the Code of Crimes Against Humanity, and so on. Why I was skeptical? Because in Ukraine and in many criminal codes and in the USSR republics, you know, all that concept was entailed with interlaced with a life story that I once heard on a conference on international humanitarian law when I was approached by some Russian participants, and that was like 20 plus years ago, and they started asking me about Ukraine's practice as to the use of this article, and then I go like, to the best of my knowledge, there is no practice, and they go like, we want to share. Yes, so we got some practice. We got some prosecutors that got drunk somewhere in the Far East, and they opened a criminal case, and that was actually a big achievement, though they did not understand what the crime was about. That was the non-serious attitude, and I felt ashamed and embarrassed because that was a very important matter. And especially there was a proposal to make changes to the Roman statute. By the way, one of the proponents to this initiative was our friend Philip, that actually formulated this idea of special tribunal for the crime of aggression against Ukraine. That was one of his favorite subjects, because he's an expert at the same time of ecological international law and international criminal law. He has both, which is a pretty rare phenomenon. And despite what is going on, and despite how bad the states, the countries are enforcing their obligations as to non-causing serious and lengthy harm during hostilities to the environment, which is, yes, done things in the first optional protocol to the Geneva Convention, and there are some obligations, but they are pretty weak, actually, and not deemed war crimes. They're not serious. They're not amounting to war crimes. So I think the proposal came in the right time, in the right place, and I would say that most likely it was actually the odds were 50-50, but there is an assumption that the Roman Statute Assembly will take this proposition. There is a need to actually deal with the common general part of it. It's not enough to actually write an article and to be usable and use the tools in the Roman statute. There is a problem with the subjective part, subjective side. It is different. It is different from other international crimes, from atrocity crimes and genocidal crimes against humanity, because there it is obviously that recklessness should be introduced as an idea which is absent. nobody knows knowledge, and so how it translates into Ukrainians, nobody knows for sure. But so you have to implement the subjective party. But there is such a proposition. It is attractive and it is correct, essentially. So hopefully it will be accepted. I don't see any big opposition. So the state might not say that it is not formulated like that. So let's hope that for a positive result. And right away, just the projections, the next projection up to 2030, the jurisdiction of the International Criminal Court will have yet another war crime. Maybe, yes. But that depends, there's a great probability, in my opinion, that the lists of war crimes in international hostilities and non-international hostilities will converge, because we've got a long list of crimes that is present in the line items that concern international things, non-international things. That's not only dogmatic but practical. Also, though we have left this stage, this area, that they are all international, they say, but in this sense, there will be a convergence, and if you look at that as a different composition, that there will be about the contents related amendments or additions, it is harder. For example, the discussion that landmines, infantry landmines, the use of them is a war crime. It won't be sustained, obviously. But other topics, for example, in my opinion, candidate number one is the use of autonomous weaponry system, the use of drones. That's the candidates to be included in even robots, that infantry robots that use artificial intelligence. Here, I think when it comes to drones and autonomous weapon systems, it would be good to work on that, on potential inclusion. But the matter is, I don't think that without these positive events, within quote-unquote international criminal law, the war, peace, and international security, the great progress might be possible. The probability is could be pretty high, but contents-wise, it's not very high. And now, Mykola, I propose that we come to some institutional mechanisms of international criminal law and talk about the International Criminal Court. And I will make a projection that probably concerns many Ukrainian citizens, which is that up to 2030, for example, one head of state, and the Ukrainians have a particular person in place in their current position, will be a defendant to the International Criminal Court in a court session, in a trial. It's difficult to say positively because he will not be effective when he appears in court, but it is construable, effective or non-effective head of state, because you can imagine a situation that the authorities have changed, and then he's not head of state formally. Is he or is he not? If the authorities of the government changes, otherwise the realities are like this: that first they're no more head of state, and then they appear in International Criminal Court, in the International Criminal Court. And that's, by the way, is a reason why the discussion that we took part, that we were so anxious about that the creation of Ukrainian Special Tribunal for the crime of aggression against Ukraine. There's a matter of the immunity for heads of states and ministers of foreign affairs. That's pretty important but abstract. Because it comes down to the possibilities, one may say, for compulsory the enforcement of court decisions, court orders, or decisions of the International Criminal Court. It is obvious that that on their own they will not have a prospect for a self-reliant mechanism of some forced enforcement of their orders, which the International Criminal Court doesn't have. Then, if none, that the state should cooperate. If state should cooperate, that the head of state or somebody like the top official or those people that in the narrow sense have vanquished that state and then detained them, and then they transfer them to the International Criminal Court, which will be an ideal option for everybody. This is why everything depends on how it's going to go on, how it's going to develop, but it doesn't look nice. Well, I've already mentioned in the beginning of our talk that witnesses to the creation of a special Ukrainian international tribunal that will look into Russia's crimes against Ukraine. And now further news or further projection is that up until 2030, another special international tribunal will be created. I don't think so, but except for our tribunal for the crime of aggression, you know, although I cannot refute that fact, depending on the unfolding of the situation. What is going on in Sudan might have been an subject for a tribunal of their own, but the International Criminal Court has a jurisdiction on some aspects, has no jurisdiction on some others, maybe, but unfortunately, but no, unlikely. Palestine, and the situation where that we have appeared to be. With the warrant for arresting Benjamin Netanyahu, you know, special tribunal. Unfortunately, it would be promising. It will be promising in this area. You've got to leave this zone. By the way, from this difficult situation, and people who are versed in this situation know we need to get out of it. They need to get out of it. One of the options will be, I think, will be relying on the complementarity mechanisms. In other words, the relevant charges with war crimes of genocide, even as they have against the Israeli government, and they should be looked at closer to the crime scene, and then they should decide whether the International Criminal Court shall take it. So I have doubts, and I see discussions around our special tribunal. And that is actually not a very costly structure. It should not be a very costly structure by its conception. There should be minimum costs, but now when they count the particular budget, they start talking about, isn't it too expensive, a little bit too expensive? Well, it is too expensive. If this one is too expensive, then one can imagine a tribunal that will investigate war crimes in where you've got to look at more detailed events, because the crime of aggression is not so generalized, not so generic and wide scale. You know, now field work, not much field work is stipulated and taken witnesses' testimonies. Another question to the International Criminal Court, and it sounds like up until 2030, at least one country will join the Rome Statute, and at least one country will exit it. It's very probable Hungary has not left it yet formally, but it's about to exit already with this government. We're not sure about the next government. Let's wish them all good luck in their democracy. But yes, of course, there will be some exits and there will be some entrances. Why? Because a few African countries have left because of the court accusations that they're only engaged in Africa. That's history already, and now the reason why they're getting out, why they're leaving, is because it is an absolutely nihilistic approach to the matter of international law. And that's on the one hand.
Other countries, we didn't expect any significant impact into that. Also, we should consider the pressure on smaller countries from United States or from Chinese People Republics, and that pressure potentially might cause such things as leaving ICC and but there will be countries who will be joining. For example, Ukraine and Armenia joining. There's a very good sign for ICC. So this will be in and out process. So to give the focus until 2030, this is very short term, because in the situation of these covered World War III as it's happening, so after the period of great wars and political changes, international criminal law usually develops in a very robust way, and any forecast we are making now might sound everything is so bad, and suddenly we will get to this point when things start developing drastically in different manner, because actions that boost development of international criminal justice, they usually very bloody, unfortunately. Another forecast for the devoted fans of international criminal law: until 2030, at least one international institution gain rights to prosecute international criminal justice, just international criminal cases. Yes, probability of such institution starting considering such cases minimal. I don't see a real chance for that, because these are courts that are working in different paradigm, because in the paradigm of international responsibility of state for complying to the Convention of Human Rights. So again, but that's how we should differentiate between the regions. Yeah, in Europe the chances are minimal, and by the way, very good and very nice administration of United States, previous one, in their behavior to the International Criminal Tribunal, and where works our friend and Mr. Kornevich is working. Yes, United States participated in the work of that, and their position was very obvious that this is something that Europeans should do for themselves, that should stay within the European community. Maybe Europe will achieve something, but not via the mechanism of International Court of Human Rights. In Africa, this is possible because there are attempts of adding this to the in the African International Court, for example, joining the Court of African Union with the Court on Human Rights, and maybe considering some criminal crime-related cases. They might go. The situation there is even more unstable than in Europe, and the position of different countries might change in much faster dynamics comparing to Europe. But I'm very skeptical about that, because courts on human rights, they react to the violation of human rights that are supposed to be qualified in the dimension of individual criminal liability according to the international law. What can be these courts might be a part of the bigger picture, but they won't be that much of significance. Their activities not that much of the significance in that field. Another my forecast, not more related to international criminal law, but it's close to it. Until 2030, all countries will leave the Ottawa landmines conventions. They will not leave all of them, because the European states are the major sponsors of these conventions, and I don't know what should happen for Switzerland to quit this convention. This is unreal. And things are very clear for me. States that don't have land border with Russian Federation, they don't have a stimulus to leave these conventions. Maybe only from just to speak in the same voice with countries that border with Russia. So maybe they will be passing over any of the stockpiles of landmines to those countries for living. And this convention shows that have issue of international humanitarian law and corresponding issue of international criminal law that shouldn't be ignored. It always this idea is very good and brilliant, but it should be founded on presence of peace and on presence of mechanism for effective disruption of armed conflicts, and on the mechanism of avoiding interstate conflicts. So here we talk about how effective is international law in preventing violence to be used to achieve certain gains. So, and this is, if this mechanism is not present, then when this split between application of force and waging wars, the topics of disarmament, because Ottawa Convention is about issues of disarmament. So these agreements, they lose their foundations. So they cannot work in the vacuum. They should found it on something, because that mechanism, again, certain projects. Ottawa Convention is a project to make this world better, because in Africa, during the war that happened during tens of by decades long, children or civilians would not perish from the landmines and wouldn't lose their limbs. Yes, we all, I don't know how many of you are aware, but there was a campaign on adopting the Ottawa Convention, and everyone was pushed to believe that it should be ratified. I remember this advertisement during the breaks of Champions League, when everyone is playing football and one child without a limb cannot play because he perished from the landmine. So that was the logic of adopting this convention, and it was absolutely correct. And everyone who been to Geneva, they've seen a chair without one leg, but without foundation, that convention doesn't work. Thank you. I don't have any more forecasts for you to ask, but maybe we have questions from the audience. Good day, Mykola Gnatovskyy. I'm from Zaporizhzhia court. I'm very glad for your thoughts and consideration. I have very practical questions. If we will have criminal proceedings against the Russian prisoner of war when they conducted war crimes, for example, they executed Ukrainian prison POWs or civilians, but still Russian state is eager to exchange them and take them out from Ukraine until we announce the court sentence. If we will have opportunity to persecute top leadership of Russia in international courts, how whether it will be sufficient to have Ukrainian court sentences to proceed with persecution of that top leadership, or we will need to involve those Russian war criminals as witnesses. Yes, great to see you, my friend from the University Times. With regards to exchange of prisoners, I will not say extensively what is my position is, because there are certain cases that are considered by the European Court of Human Rights, and my position will be depicted there, and we will formulate officially a position on exchanges of prisoners, including with regards to positive commitments of the states. Yeah. I will not dive deep onto that side, but with regards to your question about what information will be sufficient, it will be a choice to make by the Ukrainian authorities. Ukrainian authorities will estimate how particular subject is important to testify in the court, and how it will relate to other efforts of Ukraine in prosecuting as much criminals as possible, war criminals as possible. So it will be choice to be made in each particular case, criminal case, but and it's not only the efficiency of the conducting court trial will be consideration, yeah, and the other things will be in place.
Доброго дня, Микола Миколайович. Мене звати Ярослав.
Good day, Mr. Mykola. My name is Yaroslav. Thanks for participating and in this very important discussion. Question about the extradition: how to return person? How, for example, how to extradite person that is convicted for treason, for example, from countries like Poland, Germany? Thank you, Yaroslav. I will be very brief. I can say that according to the general procedure, so there are requirements that international law already has for each state, and Ukraine just have to abide to those requirements. And with regards to cases of state treason, it's a crime that definitely has political side to it. So the country that will be releasing that person will take their own opinion about how objective that conviction. Yeah, so there are considerations that Ukraine is like there are procedures that Ukraine is now following in order to make sure that the country that is releasing the person is sure that Ukraine will adopt, will follow that international humanitarian and criminal law practices. So, like starting like from the issue in which institution that person will be held in, like, and so I can say that Ukraine should follow the general process for extradition. So, and last question to Mr. Mykola. Diana, lawyers advisory group. Mr. Mykola, maybe you have any advice to our courts, lawyers and prosecutors, for example, when the process under trial is Russian military. What procedure should be taken in order to avoid later appeals with regards to the violation of human rights? How to build this trial process and in order not to face such issues, because attention of society to such cases is high. Well, also, and for example, if case is considered in a closed hearing, usually this race of it faces so concerns from the general public, and whether these court trials should be closed or open. So what's better from the point of view of international criminal law? Yeah, that's a very delicate issue, but thanks for being concerned on that, because it's very good that you are asking these kind of questions, and the answer should be very thoroughly considered. What to do in order to avoid complaints to European Court of Human Rights? I cannot answer you, because the complaint can be justified, grounded, ungrounded. Yeah. So, but on the side, how to adhere to the requirements of Article 6 of European Conventions. So, like, from it's very well drafted, and because we have knowledge-based platform in place, and so the question you ask about open or closed trial, like by default, we see that the trial should be open. If the trial is closed, the court should give grounded reasons why they're closing it and to what extent they're closing consideration of that case. Yes. Maybe there might be parts of the trial that protect victims from re-traumatization, and obviously it's right to move to close court hearing in that manner, but that But the task might be difficult. So to define in which part to close the trial. So, and I don't envy the judges who will make those decisions where to open have open or closed hearing. So, and I can only wish luck to everyone who will be involved in that process. Thank you, Mr. Mykola. Thank you for this conversation. We discussed not only international criminal law, but other topics. I was very glad to see you. Unfortunately, for a number of years we're meeting only online, but hope next year we will meet in person in Kyiv. Yes, I also hope for that. I was very glad to talk to you. Thanks for inviting me to this, and I wish you a successful week of international criminal law in Ukraine. Thank you.